My name is Richard Bechtol. I'm one of the attorneys here at Royal Legal. I'm going to talk about estate planning. I'm going to kind of give a broad overview. It's kind of the ultimate guide to estate planning. All right, so a little bit about me, as Tammy spoke about. I I am a real estate investor myself. My background is estate planning. Prior to joining Royal Legal, I basically solely did estate planning and estate administration. My last position I held was actually with a firm. It was the largest elder law firm in the state of Ohio, which is where I'm located. And in that position, I handled all of their probate, trust administration, and then I handled estate planning, as well as Medicaid and some other areas. But my main focus was the estate administration. So when I'm talking about different, I guess, scenarios and things that I've seen with estate planning and with individuals who have not done proper planning and some of the issues that I've seen. I have a lot of experience on both sides, whether that's like completing an estate plan for someone or seeing the other side of it when they don't do any estate planning at all. And I have to administer their estate with really nothing put in place. All right, so let's start by who needs an estate plan. Really, anyone with any assets at all should have an estate plan that is 18 years or older. Children don't really need an estate plan. But if you're 18 years or older and you have assets, you need an estate plan. Now, in particular for you guys and the individuals that I speak with a lot at Royal Legal, just in general, it's especially important because it's individuals who own a business. Um, your real estate investing is a business, so you definitely should have an estate plan in place if you own a business. Um, I've handled estates for individuals with businesses. I've handled some interesting businesses. I've done estates that were people who owned real estate, people who owned a gun shop, someone who owned a gentleman's club, someone who owned a bar and deli. And some of them had estate plans. I would say about 50-50, and some of them did not. And I can tell you that the individuals who did not have estate plans, the process was a lot longer, more drawn out. Even a couple of them that had estate plans, they just had a will-based plan, which is not a good idea when you own a business or have substantial assets, because it still is a long, drawn out process. All right, so then why do 70% of people die without an estate plan in place? That's a good question. I have had an estate plan in place since I was in my early 20s, but that was before I was an attorney, but I also served in the military, and they force you to have one when you go to a combat zone. So I have had one in place for a while just because of that. But if I was not one of the individuals like going to a combat zone, I probably wouldn't have one in place. My parents are both in their late 60s, and I can tell you that until I became an attorney, and this was my focus, they did not have an estate plan in place. And my mom and stepfather had about 6 to 8 rental properties, and they had no structure or planning in place. So it definitely happens. Don't feel like embarrassed or anything if you don't have one currently. You should get one in place, but it's definitely a lot more common than most people think for someone to not have anything in place. Some of the reasons that I've heard is probably the most common one is most people believe that only the ultra wealthy need an estate plan. So they believe that you need to have a lot of money, a lot of assets in order to have an estate plan. That's simply not true. You could have just a car in your name, and you should have some sort of plan in place to get that vehicle transferred from you to someone else upon your passing. It might not be a traditional estate plan that everyone thinks of, but you need something in place, because ultimately what's going to happen if you have any assets and you don't have a plan in place, they're going to have to go to the court It'll have to go through the whole process with the court, and it's just going to chip away at the value of your estate. Now, when I used to do estate administration, I had a minimum fee of $2,000. So even if like there's a $5,000 car, you're gonna have to pay an attorney about 2 grand to get that $5,000 car transferred. So it ends up that's almost half of the value of the vehicle just getting it moved. So it does take time and effort from an attorney. So don't think just because you have something really small that it's not going to cost you anything. And the court's not going to help you with the process because they're not allowed to because it's giving legal advice. So you're pretty much 90% of the time you're stuck paying an attorney to do that. So it's going to cost your family time, money. It's hard on them. So you should have a plan in place for any assets. Another thing that I run into a lot, which I'm only 30, so is that it's uncomfortable for people to talk about their death. I get that a lot, and I get oftentimes people talking about that it's kind of weird that I'm 30 and I sit down with people and talk about their death on a regular basis. I don't think it's that uncomfortable of a topic. It's the old saying, death and taxes are the two inevitable things. Everyone's gonna die, unfortunately. And ultimately you want to make it as easy as possible on everyone else. Once you're gone, your family's already going to be going through a traumatic time. Friends, everyone, you don't want them to have to go through the ordeal of dealing with a court, dealing with an attorney, dealing with this and that. In addition to trying to process your death and everything else that comes with it. So it's an uncomfortable topic, but it's one that if you don't address it now, you're going to end up dead one day, unfortunately. So someone else is going to be stuck addressing it after you're gone. Many people procrastinate and they say, I'll deal with it when I get old. I know the goal is to live a long, happy, healthy life and to ultimately do this when you're 70, 80 years old, when you're getting closer to the end of your life. But not everyone's dealt that hand where they get to live a long, happy, healthy life and then pass away in their 80s, 90s with no prior issues that you need anything in an estate plan for. Ultimately, that doesn't happen very often. You don't deal with that often. Something comes up, whether it be a stroke, a heart attack, some sort of incapacitation, Alzheimer's and dementia. I dealt with a lot when I worked in elder law, something along those lines. And if you get to the point where, say, Alzheimer's or dementia, because it's an ever-growing area, if you get to that point where you are not remembering things and not understanding, you're not going to be able to sign anything. So you've got past the point where an estate plan can help you. And that's when the court has to get involved. You might have to have someone appointed as a guardian, which I've done those in the past too. I don't do those anymore. They're not an enjoyable thing to deal with at all. And then ultimately, many people believe that it's expensive to create and maintain. Again, that's a myth. It should cost maybe a couple to a few grand, depending on your situation, to initially create. You want to do regular maintenance, maybe review it every 2 years to 5 years, plus any major life change. However, if there is a change that needs to be made, a lot of times it can be done very inexpensive, couple $100 to make the change. A lot of times people think there needs to be a change when there doesn't actually need to be a change. So like an example would be if you acquire more assets, you think you need to update your trust because you have more assets. You don't necessarily need to update your trust. You need to update the title of the assets, which you don't need an attorney to do, so it's not as expensive. So initial startup cost is going to be maybe a couple to a few grand. The maintenance cost is a couple to a few $100s anytime a change actually needs to be made, which is a lot less than the 5 to 10% that going to probate could cost you down the road with what you're leaving for your family. So it's more expensive to not have a plan in place than it is to create a plan. All right, so what can you do on your own? So a little bit that you can actually do on your own without the assistance of an attorney involved in an estate plan. First, you can create an inventory of all your assets. This can be done with a spreadsheet. You can use software programs. Royal Legal, I believe, has a inventory template as well. But what you want to do is create an inventory, list all of your assets. I'll go over in the next slide what your assets consist of. Next, you want to determine who your fiduciaries will be. So fiduciary would be your executor or personal representative to deal with the court, your power of attorney in case something happens to you and you need someone to handle your business, trustee, someone to handle the actual trust. So you want to determine who will fill that role before you meet with the attorney, or the attorney can help you, but that's more of a personal question. And then another thing is you want to determine who your heirs or beneficiaries will be. You want to determine who you want to leave stuff to, how you want to leave it. There's some questions that we'll go over for that as well, with kind of determining who your beneficiaries will be. All right, so what assets are part of your estate? You have real estate. That could be real estate in a business, real estate you own personally, real estate you own with someone else. Basically, any type of asset involving real estate would be included in that. Ownership interest in a business as well would be included. Vehicles that you own outright. Personal property, your items, your things, couch, chairs, collections, any of that. Bank accounts, stocks, bonds, mutual funds, and CDs, life insurance accounts, retirement accounts. You really want to sit down and take a hard look at what assets you actually have and think about each one of them individually. I can't almost guarantee, but I can say probably about 75% of the time, people will give me a list of their assets. We'll get to talking. They'll have missed or forgot something. So it does happen. The reason for creating the spreadsheet is, like we talked about before, whoever's taking over once you're gone is going to be going through a traumatic time and event. You don't want them to have to be searching filing cabinets, searching your office, looking up and down everywhere to try to find a statement from an life insurance policy, something about a stock you owned, things like that. You want it to all be kind of centralized, make it easier, smoother on them. It just makes the process easier for everyone, makes for a less traumatic time. I can't tell you the amount of families that I talk to where, say, the second parent passed away and they're working with me, but when the first parent passed away, just trying to find everything that they owned. And it feels like the older the person is, the more random assets that they have instead of just like a few. A good example would be my grandparents. I'm helping them get all their stuff in order, and they don't have a lot, but they have about 12 different life insurance policies between two people. And there are small policies here and there and everywhere, but they have 12 of them. So things like that, you really gotta keep an eye on. Christmas club accounts are another one that were like the bane of my existence when I was working in elder law. So many people forget they have those. There'll be like $500 in it. Like I said before, it was $2,000 for me to do an estate. So you're 1,500 in the negative just trying to get that put into your name. If you don't get it put into your name, it becomes unclaimed funds with the state of Ohio, and then you still have to get an attorney to help you at some point, or eventually it just goes to the state of Ohio and they get to keep the money. So, all right, finding fiduciaries for your plan. So again, fiduciaries will be people to run everything, keep everything going, deal with the courts, deal with your bank, everything once you're gone. So some good questions to ask when you're trying to decide on a fiduciary. How complex is your estate? Is it something simple? Do you just have a few things fairly straightforward? Um, is it very complex? Do you think that someone in your family can do it? Do you think you need to hire like a bank trust department, a corporate fiduciary of some sort to do it? That's one thing to think about. Another thing is if you have someone lined up in your family or a friend, what's their financial skills like? Are they good with money? Are they good with investments? Are they good with financial decision making? You need to have someone that's good with finances to act as your fiduciary. You don't want someone who is really bad with money to step in that role and act as your fiduciary. Um, Another one, what are your family dynamics? This is a huge deal. The divorce rate is very high, like 1 in 2 marriages end in divorce. So you get a lot of blended families now. Well, what are your family dynamics? What did you have before you and your current wife got together? What did you guys have together? How do you want stuff you had prior to pass? Another thing is, do you have any children that are like to take advantage of their siblings? Do you have any children who are kind of bad apples, so to speak, that have issues that might cause them to try to take advantage of someone to get some extra money? So family dynamics play a huge role in this. I've had numerous families that I've dealt with where maybe I had one where they were married 30 years. So she was the stepmother. The father passed away. It had been 30 years that they were together. There was a son who was only still in his 30s, late 30s, who apparently held a grudge for that whole 30 years against the stepmother. And as soon as the father passed away, he told the stepmother that he wasn't talking to her anymore and had no business dealings with her. Well, he was entitled to money through the trust, but what she ended up doing is starting another trust, moving all the money from the one trust to the other trust, and then he basically got nothing of his dad's because he was not wanting to speak to his stepmother anymore and wanted nothing to do with her. So she just took all the money that was left to her and he didn't get anything. So you really got to pay attention to family dynamics, especially in blended families. Another one, should they be compensated? That would be where you would want to maybe have a bank fiduciary, a corporate fiduciary. They're always going to be compensated. It's going to chip away at what is in the trust. If you have a friend, maybe you have a friend who's really good with money or finances or understands your business structure, your business model. Are you okay with them being compensated for your trust and running your trust or handling your estate? If you're comfortable with it, then that's good. If you're not, you might want to think about that because a friend is more likely to ask for compensation than your child or your spouse. Do I want more than one person to handle the role? Do you have 2 children? You worry about one thinking that the other one's taking advantage of them. Do you want them both to do it? If you have 2 people, do you have 2 people who can get along? Because it can definitely stall the process if you have 2 people and they can't handle anything. I had an estate with 2 administrators. Those are the 2 children. One of them had nothing to do with the mom. The other one was like in-home care for the mom, passed away, and the daughter said she wanted to be a co-administrator. The son couldn't do it by himself. She was worried he was going to screw her out of stuff. So then you had the 2 of them who they hadn't spoken 20 years trying to work together on stuff. That estate, when I left my previous firm, that estate had been open 18 months and they hadn't even sold the house that she had. So you can definitely run into some issues when someone else steps in and says that they want to be involved, especially someone who hasn't been involved for most of the individual's life. That can happen quite often as well. Another issue with real estate investors with you guys would be, do I want them to keep my business going? So you guys are working on building these businesses, building portfolios. Do you want them to keep it going? Do you want them to liquidate your assets? What's your ultimate plan? Do you have maybe a child that you kind of mentored who has an interest in the same thing that you can work with so that they have the skill set to keep your business going? Do you have a third party business partner that can keep the business going and maybe your children can just financially benefit from the business, something along those lines. But I've noticed since I've been working at Royal Legal with investors on building this, a lot of people want to keep their business going. They didn't build it for the day they pass away, for everything to be liquidated and the money to go out. So if your ultimate goal is to keep your business going, you really want to pay attention to your fiduciary, make sure they have the abilities to keep your business going. All right, next is beneficiaries. So who are my beneficiaries? Are your beneficiaries minor children? If they're minor children, then one of the things that you definitely need to do is you need to pay attention to, do you have a will-based plan versus a trust-based plan? Do you trust your children? Which I would say you probably most of the time should not, but do you trust your children to, when they turn 18, get whatever they're entitled to and not blow it on something silly? So do you have minor children is a big one. Another one, do you have beneficiaries who have substance abuse issues, financial issues with like your son or daughter-in-law? So spousal issues that you see might affect them in their life. So do they have some sort of issue in their life? You might want to plan for that. Another issue could be, are they on some sort of means-based like government assistance, because you don't want them to inherit everything and get kicked off of that, because then all the money you work so hard for that you pass to them is just going to go to the government in the end. Another thing is, do you have contingent beneficiaries for everything? So do you have a backup? Say you have your children, do you have a backup for your children? Is it your grandchildren? Is it your siblings? Is it your parents? You need to think about who your backup for your beneficiary would be. Do you have charitable interests as well? Do you want to pass something to charity? How should we plan for that? Do you have your beneficiaries updated on retirement accounts and life insurance policies? If you do not and something happens to you, those could end up in the probate court, because if say your spouse is your beneficiary and they pass away before you or with you and you don't have a backup listed, it's going to end up in the probate court. All right, so does a will-based or trust-based estate plan work best for you? All right, let's start with will-based planning. So I hear all the time, I have a last will and testament, I should be good to go, right? Probably not, unless you've done some other planning as well. The reason for that is a will-based plan, it's going to include a last will and testament, a financial power of attorney, living will, healthcare power of attorney, possibly a HIPAA release form as well. But what the will is it's just simply instructions for the probate court. What that means is it still has to go to the probate court. So your will is just telling the court what your wishes are, but every item still has to go through the court in order to be passed to whoever it is. So say you have a will-based plan and your children are minors. Well, then the court's going to have to create a trust for any child under 18 years old. What that means, if the court creates the trust, is that in order to do anything for that child using the money in the court created trust, you need court approval. You have to do annual reports with the court. You have to file reports with the court, show them what you pulled $1,000 out of the trust to spend on the child. The court has to approve everything that's done with that money. I don't know about most of you, but I know that I want the court to be and the government to be involved as little as possible. And when you do the annual reports, they're not that easy to do. So most of the time you end up hiring someone to do and have to pay fees for that. In addition, there's no additional control. So kid hits 18 years old, now they can have everything that's in that trust. That is probably a recipe for that money to be spent. You can not put any additional control, any speed bumps. Um, Whenever the person gets the money, they're free to do with it what they want. Another issue is, since it's in the probate court, it's public record. Anyone can see it. There's an inventory of the assets that tells what they are and the amount of money. There's a report within the court that shows where it went, who has it now. So all of it's public. You get no privacy whatsoever. It's time consuming. It's Probate's probably going to be at least 6 months, probably closer to 12 almost every time. It's a long drawn out process. You have to pay court fees, attorney's fees. You have to do all these reports. It's not an enjoyable process. Also, it opens up creditors for both you and your heirs. So whatever is in your estate that's with the probate court, if you have creditors, they can make claims against that and take that money. Also, if whenever it passes to your children or your heirs, then their creditors can access whatever was left to them. So that's another situation where it's not enjoyable for either of you. And like I said, it's just unenjoyable and expensive. The probate costs are roughly 5 to 10% of the estate. So it's just not an enjoyable process. So you might save a little money on the front end by paying for a cheaper plan, but it's going to end up costing more on the back end. All right, trust-based planning. So one of the main features of trust-based planning is that there will be no involvement by the probate court most of the time. If you set it up and fund it correctly, title your assets correctly, then you should not have to deal with the probate court at all. It gives you some additional control. You can set up speed bumps. You can say that your children, when they reach 21, 25, 30, 35, get a certain percentage of the assets. You could set up later than that. I've had clients who their children are reaching retirement age and have done nothing to prepare for retirement. So they set theirs up to where it starts at like 55 or 60, they start getting access to it. It gives you some additional control over what you've worked your whole life for. Since it's not involved with the probate court, it's not public at all. So the court doesn't get to know any of it. It's quick and inexpensive. So it takes 6 to 12 months to do probate. It takes 4 to 8 weeks, 10 weeks to do trust administration. So the timeline is drastically different for trust administration. There's protection against creditors. So if your trust has a spendthrift provision in it, it protects the beneficiaries from creditors. You're protected from creditors because they make claims against the estate with the probate court. So they only make claims with the court. They do not get to make claims with what passes not through the court. So you're protected there. Then you have protection for disabled heirs. If you have someone who's on a means-based form of assistance, when something passes to them through a special needs trust or a trust with a supplemental needs trust built in, then they're not going to be kicked off of that for receiving an inheritance. All right. So addressing real estate investors' needs within the trust plan. So some of the things that I've previously discussed and that Royal Legal specializes in, but providing privacy for future generations. So a lot of our clients come in because they want that anonymity. Well, if you don't do some sort of estate planning, your anonymity is going to be gone once you pass away. Here, you can provide that anonymity for future generations by avoiding the probate court as stuff passes. You get additional control over the assets. So that is another thing that I've noticed about real estate investors. And I have some issues with it myself. But a lot of real estate investors, they enjoy the control kind of. We have type A personalities. Well, this allows you to kind of keep your type A personality going even after you're gone by allowing for some control over the assets even after you're gone. So you don't just build this portfolio up, pass it to someone else, and then it's just Here you go, do with it what you want. Here you can build in some additional control. Also, you can allow the business you have built to continue on. So you can build it into your estate plan, your trust-based plan, that you want the business to keep going. You don't want it to just be liquidated and gone. If you do a will-based plan, it's going to pass to someone and it's their choice. They can do with it what they want. If they want to liquidate it, spend all the money on a new car, something, they can. You're protecting your portfolio for your heirs. So you're protecting it from creditors for them, from the government, all of that, you're protecting it. Another one is you can get the tax benefit of doing a testamentary gift instead of a inter vivos gift. So instead of gifting while you're alive, which can hurt you with maybe the capital gains tax, things like that, if they do go to sell a property, you can benefit from having it passed to you upon your death so that they can get that step up in basis for capital gains. So there's some definite tax benefits to not just turning your portfolio over while you're still alive to a child. All right, and then this is how a estate plan and a living trust fits into a business structure. This is an example of one that we would set up here at Royal Legal and how it would all tie together. So you would have your LLC tie into your anonymous trust to provide your anonymity. That trust would tie back to your living trust. Same way with an operating company. So any business structure that you do, you can have it tie back in to your living trust and ultimately your estate plan. So some people get confused about how it ties together. So this kind of shows how everything flows back to the living trust, so that the living trust is ultimately the end result for all of your business structure. Now, you can also title your personal assets. So maybe your personal, your residential property, things like that, you can title to your living trust. Your beneficiary to life insurance could be your living trust, things like that. So you can tie in your assets that are not part of your business structure into the living trust, but this is what it looks like tying in your business structure as well. All right, and then do we have any questions? I know this isn't quite as enjoyable of a topic as like different investment tools and investment ideas, but it's ultimately, it is a topic that's inevitable for everyone, unfortunately. So I'd be happy to answer any questions that anyone has about this.
Thank you, Richard. It does look like there is one question here in the chat. Brenda asked, do you know if it is similar in Canada?
Yes, I do believe it is fairly similar in Canada. There's like some minor differences, but for the most part, it's a similar process with everything in Canada as well. When you have US businesses but live in Canada, so when you have US businesses but you live in Canada, you want to make sure you have some sort of like trust-based plan. It's going to be similar to what it is when you have, say, businesses all over the United States or real estate all over the United States and you live in a particular state. You're going to have to, if you don't have some sort of trust-based plan in place and you have a will-based plan, you're going to have to set up something in it. A trust-based plan will tie in all the different states and regions, where a will-based plan, you would have to basically go through the court in each individual location. So with the US and Canada, if you have a trust-based plan, you should be able to tie in everything from both countries together so that you don't have to go through the process in each state, in each country. All right, the average cost to set up a living trust is going to be it's going to be roughly a few $1,000s. It varies a lot, but you shouldn't be paying probably more than $5,000 to set one up, but it's going to be at least a couple grand. So it really does vary a lot, but the average cost I would say would be between $2,000 and $3,000. All right, and then Derek asked who he needs to call to set this up. I believe they dropped the quiz into the chat. You could do the quiz to initially get going, and then they can set you up with a consult with me to set one up. And yeah, even if you're in New York, we can assist people in any state with this process. I think that's everyone, all the questions
All right.
so far.
Okay. Any other questions? Derek had said, where can I get the inventory work form? Is that the form that Liz had put in the chat earlier? Liz, would you mind putting that back in there again? Also, Liz asked, Richard, do you want to talk about the difference between power of attorney?
Oh, the different types of power of attorney? Sure. So there's the healthcare power of attorney, and then there's going to be a financial power of attorney. I always like to, I had an old boss who used to say this, but the financial power of attorney is probably the most important document out of all the documents in an entire estate plan. And the reason for this is because when you need someone to handle your finances, it most likely is because something happened to you, some sort of traumatic event to the point where you're incapacitated enough that you're not able to sign one at that time. So you need to have one of those in place and prepped and ready to go on the chance, because I mean, no one anticipates you're going to have a stroke, in a car accident, something like that. But if something like that happens and you don't have a financial power of attorney in place, then your family is going to have to go through the process of getting a guardianship for you, because you're not going to be in the mental state that allows you to sign one. So they're going to have to get a guardianship in place. And like I said before, I've done guardianships with the probate court. It's probably the least enjoyable process for dealing with the probate court. What they want to do is they want to look at basically your finances and everything about you as the individual wanting to get the guardianship. They want to look at the finances and everything about the person you're getting the guardianship for. So they want to pick everything apart for you, both you and the individual you're getting the guardianship for. They want to dive into all of your personal information. And then once you get the guardianship, the ultimate person in charge of everything is going to be the court. So you have to get court approval to do almost anything once you have the guardianship in place. It's an extremely restrictive process. It's probably worse than going through probate, to be honest. So in order to avoid that, we really want to have those powers of attorney in place. So when I talk about that, it's roughly between $2,000 and $3,000 for a living trust plan. You want that plan, when you speak to the attorney, you want that plan to include a living trust, a financial power of attorney, a healthcare power of attorney, a living will, and a last will and testament that's called a pour over will. So you want to make sure you're getting the full package from an attorney. So the $2,000 to $3,000 includes all of those 5 documents plus the living trust. So you really want to make sure that you get a full comprehensive estate plan. You don't just want to have an attorney offer to make you just a living trust, because you're missing out on so many things. We're not all going to go to sleep one night and not wake up the next day. We're going to have health issues along the way and things happen to us. So you want to be prepared for all of those situations. All right. I see a question about a land trust. Okay, what should be included is the financial power of attorney, healthcare power of attorney, living will, last will and testament, and the living trust. And then a HIPAA release form is another good idea. We do those here at Royal Legal, but the HIPAA release form just allows individuals to be able to basically be included and talk to your doctor about your health issues. They can't make decisions for you, but they can at least speak to your doctor and be included in stuff, so they're not left out of the loop. Oh, and in general, to set something like this up, it takes about 4 weeks from like when we get you in and do the initial meeting is about the time frame for getting it set up.
Hi, Richard.
Yes.
Hi, this is Charlie. So,
Hi.
hi, how you doing? Great presentation. Thank you. The
Thank you.
So the trust itself, the land trust, you're saying that it takes 4 weeks? Or are you talking about the general trust the trust in general?
I'm talking about our time frame for pretty much anything we do here at Royal Legal is 4 weeks. That's what our turnaround time typically is.
Right,
So
right.
we can expedite, but it would be a fee, but the general timeline is 4 weeks.
Okay. Because I know you guys had a timetable somewhere between 4 and 8 weeks, yeah?
Yeah,
roughly.
we've cut it down to about 4 weeks now.
Awesome. Awesome. Great
Yes.
news. Okay. Okay. Yeah, I just wanted to check on that.
Yep.
Okay. Great. Thank you.
You're welcome.
All right. Well, thank you so much, Richard, for that presentation. If anyone has any more questions, you want to go ahead and throw them in the chat now or jump off the mic, or else we'll go ahead and start getting wrapped up here for the day. It looks like Katrina asked, what documents do you like for the client to make available to the attorney? Is this the inventory spreadsheet that is in the chat?
Yeah, so clients, what they should make available, that's going to ultimately depend on the client, but it's a good idea to have the spreadsheet like available to the attorney so that we know everything that's part of your estate. And then that way, once you guys are gone, well, like passed away, whoever is handling taking over for you, they'll typically reach out to the attorney who completed the documents. So if they have access to the inventory spreadsheet and we have access to it, we can be on the same page when discussing stuff, and they don't have to get it to me for me to review before they reach out to get a hold of me. So that's a good idea to have available. The rest of your documents you don't really need to have available for the attorney. Usually you'll just want to keep it in a nice safe place, but what you want to do is whoever is going to be taking over once you're gone, you want to make sure they know where it is. They don't have to have like a copy of it currently while you're living, but they just need to know like, hey, it's in this safe. Here's the code for the safe, or I keep it in my desk, bottom left drawer, something like that, so that they're not frantically searching once you're gone.